if you've had a loved one pass away and there is no will, it's not the end of the world. A will makes things easier, but there are several options. And so the range of options runs from doing an affidavit of heirship, which is cheap but may not work, to a full-blown administration at the court and a declaration of heirship at the court. So we're going to review the various options that you have. The first option is if all that is involved is real estate, one home, a homestead in particular that the decedent owned for a long time, an affidavit of heirship may work. Sometimes an easy option to wrap up an estate is an affidavit of heirship, but it has a very limited use. First, it probably will only work for a homestead. Understand that affidavits of heirship are really a procedure not endorsed by the Texas Probate Code. Nobody has to rely on an affidavit of heirship. An affidavit of heirship is just a sworn document filed in the real property records, usually signed by two people who know the family but aren't family members, that describe the decedent's marital and family history, and therefore it establishes who the heirs of the estate are. Title companies will sometimes take an affidavit of heirship to transfer a deceased a person's interest in their homestead that they owned for a long time, if all of the family members are also cooperative and probably sign the closing documents as well as filing the affidavits of heirship. A title company is not required to accept an affidavit of heirship. It has not been approved by any court. It is simply evidence of heirship that they may rely on. So it's worth a try in some circumstances because it's inexpensive. You may not need an attorney to prepare it, or you may seek an attorney's assistance to prepare it. You simply file in the real property records. The filing fee is probably going to be $30 or something in that range. So it's very inexpensive. It just may not work. Can an affidavit of heirship work to transfer estate assets? An affidavit of heirship is not a true probate proceeding. It's not authorized by the Texas Probate Code. It is only mentioned in the code as an optional procedure that somebody can rely on if they choose to. Virtually no bank will accept it to transfer a bank account, or a brokerage firm use it to transfer stocks and bonds and other investment accounts, oil and gas interests. Those interests are just not going to be transferred in almost any circumstance by an affidavit of heirship. An affidavit of heirship may work to transfer the decedent's homestead to the decedent's children if the family issues are not complex. Other than that, it is a procedure that does not work in most cases. If we're dealing with an estate with no will, do you have to go to court to deal with probate? When there's no will, you almost always still need to do some sort of probate procedure at court to officially and effectively transfer the assets of the estate. If there are no assets, you don't do probate. So you're talking about what is there and what do you have to transfer and how can you transfer it. If we're dealing with bank accounts, certificates of deposit, stocks, bonds, oil and gas interest, you almost certainly have to go to court. Real estate interest, usually you have to go to court. And court involves, are you just declaring heirship, or are you opening an administration? And if so, what kind of administration are you opening? So if you need a court procedure for an estate, but there is no will. What are your options? The most basic option is to go to court and do a formal declaration of heirship, where the court makes a finding, enters an order that says, here are the heirs of the estate, and here's how the assets are divided. That needs to be done in any formal estate procedure where there is no will, but you can stop there and do only a declaration of heirship if there are no debts of the estate, they've all been paid, and all there is to transfer is real estate, usually a home. I often get asked the question, you know, my parent or relative died a great number of years ago. Nobody ever did probate. Can I get that house deeded to me in my own name? And the answer is not exactly, but that's what probate does. And even if it's been a long time, you can go to court and do a declaration of heirship proceeding. And the heirship proceeding will be resolved by a court order that says this is who owns the estate property. And therefore, if title is in the name of the decedent, then the title company will see this declaration of heirship and see who the new owners are. So it doesn't occur by deed, but effectively the declaration of heirship deeds the property to the heirs of the decedent.